For joining us is Anna Kaminsky, a law professor and director of the Criminal Defense Clinic at New York Law School, and Misty Maris, who is a defense attorney. And so let's talk a little bit, Misty, about what's been going on just in the last half hour with this kind of focus on Michael Cohen's sources of income before, during, and after Trump becomes president, and what he did for that income, and how that's now throwing on what this 400,000 plus payment was all about.
Absolutely. So you know that this is where the defense was going to go, because one of their arguments is going to be, well, this really was a retainer, whether or not it was more memorialized and it was in writing. It's not just the Stormy Daniels payment. It was more. You had these other consulting agreements. You made money from the Trump organization outside of that. So that's going to be one of the arguments that we see Trump's team making in closings. And that's why there's so much focus, because what they're going to try and say is, well, we called it a retainer. Well, that's not really improper. It's not going to fulfill that level of falsification of business documents. Now, on the flip side, you know, the Stormy Daniels payment is the lion's share of that. And Michael Cohen testified about structuring that payment as such in these $35,000 increments specifically to pay him back, plus his taxes. So, you know, of course, the defense attorneys are going to make that argument and poke holes, but I don't know if that's necessarily going to hold water at the end of the day.
And Anna, we've been reporting the jury reaction, how they aren't as engaged. Some rubbing their eyes, some holding their head in their hands, some looking around, watching people come in and out of the court. And I'm wondering, is this necessary? Does Todd Blanche need to continue on with cross-examination?
Well, we talked a little bit about this last week. This is that really hard balance, because what has to happen is, on the one hand, you've got to keep the jury engaged, right? You want them to be listening. You want them to be understanding what you're doing. On the other hand, if you don't get out particular facts, you may not argue them during summation. So right now, the defense is making sure it's getting out every single fact that it wants to be able to argue later on summation. And so that balance between, we're now, 2.5 days in? I mean, this has been a long examination with needing to get out every fact that they may want to argue on summation, and that's what they're dealing with right now. But listen, we've got to be mindful. They've got to be mindful that as jurors zone out, it doesn't matter that you tell them you got it out during your cross-examination. They may not have heard it because they got bored.
Well, and so do you see, Danny, as a defense attorney, a closing argument coming into focus with where they're going here?
Yes. I mean, they really have a limited set of options here. They're going to pound the podium on reasonable doubt. I know that's coming. They're also, I think, going to point to the empty chair of Allen Weisselberg, and they're going to call Michael Cohen a liar. Now, one of the things in cross-examination, there's this sort of expectation. I think you can blame the movie A Few Good Men or TV or whatever. And we've talked about this on the show before, which is you expect there to be this explosive moment. It doesn't really happen that way in cross-examination. You're looking to get concessions that you put on your yellow notepad, and you assemble them at the end, and then you highlight those in your closing argument, because it's human nature. No one, including Michael Cohen, is going to admit willingly that they were wrong or that they lied. They're going to try and waffle out of it in some way. So you're always going to get an unsatisfying answer when you try to pin someone down. Although there are moments today, for example, you stole from the Trump organization. Yes, I did. That was a huge concession. He didn't try to waffle out of his answer or say, well, not really. I thought of it as a reimbursement for all my hard work. No, he admitted that he grabbed a bunch of cash and stole it. So major concession there. But the real moments happen in closing when you marshal all of those facts together. And the bottom line is you never, ever, ever know what a jury is going to seize on. Sometimes they seize on something that is inconsequential. Sometimes it's flat out irrelevant to the actual case. But that's what they lock onto. That's what they end up discussing. And then when and if you ever find out as a lawyer, you think, that's something I didn't even think was. Look, everybody's nodding their head. They've all had that experience. You think that's what you focused on? That wasn't even in the back of my mind. And yet it's that leads attorneys to engage in overkill. It's because you never know. It's easy for us to all say, this should be more surgical. I've been saying it. He should move on. He should tighten everything up. But we're not in there. And when you're in there and it's your case and you know the facts cold, more than any of us ever will, including me, there is this tremendous fear that if you leave anything out, you might have missed that one thing, even if it's inconsequential, that the jury would hang their hat on and render a verdict in your favor.
So, Kristen, what's the responsibility now for the prosecution? And then talk to us, if you would, about the ever important judge's instructions.
Yeah, so right now I think the prosecution on their redirect really needs to build or rehabilitate Michael Cohen. They need to rebuild him, particularly after what I thought was very effective, the effective testimony that was elicited by Blanche about how he stole that money. They need to reinstate him as a human being, as someone that the defendant, Trump, found, someone that the prosecution didn't necessarily pick to deliver this testimony, and really highlight on the fact that Cohen may have been a liar, may have some inconsistencies, may have some issues with his recollection. But when it comes down to the falsification of the business records, when it comes down to who paid that money to catch and kill the Stormy Daniels story, whether or not it was real or false, and when it comes down to how that money was repaid, therein lies the crime. And all of the stuff the defense wants to kind of focus on is irrelevant, because that is what Michael Cohen testified to, and all of that was corroborated both by other testimonial evidence as well as tangible documentary evidence.